Happy Thursday, everybody. Thank you again to everyone who is joining us and watching live and also on the replay. So this week's Facebook Live in the Art of Estate Planning is all about aged care and how this impacts on the estate planning discussion. Now, I added Michael now. We're just waiting for that technology to work, but hi, Michael.
Hi, Michael. Hello, how are you?
I'm well. How are you?
How are you? I'm doing good.
Now I'm hearing myself.
Back.
Are you getting that?
Not really. Only a tiny little bit.
Okay, and you're just watching us on. Sorry, it's a bit distracting. You're just watching on the phone. You're not replaying as well.
No, just on an iPad.
Hi, Jane and Mohammed. Are you getting my voice reverb back? Yes, I think Michael, we're going to have to do some tech workshopping.
If that helped a little, I've turned the volume down.
No, so you're just playing me. Oh, Jake is suggesting headphones.
I'll see if I've got some.
Okay. Oh, I've had this problem before. So you're just connecting through one device. You're not replaying the live.
No, just through one. I'll try on a phone quickly. That might change it.
Okay. Sorry, I don't know. I haven't had this issue. Thanks for your suggestion, Jay. Okay. The joys of technology. Well, thanks, Mohammed and Jake, for watching. While we just wait for Michael to join back in, I just want to say amazing contributions in the Facebook group this week. Thank you to everybody who's contributing. I think, maybe I just need to start giving out prizes, because I think Christiana needs a prize for the funniest post. She's gotten that 2 weeks in a row, and creating some really hilarious discussion. So I might get onto that and work it out how we can start creating a post of the week or something like that. Now, while I'm waiting for Michael to come back on, who have we got? Have we got some financial advisors and some lawyers? I'm just checking who we've got in here. Oh, Michael, you're back, are you? Let's see. Jake, you're an FP. Great. Do you do much in the aged care space too? Okay, cool. Not much. That's all right. Well, I've got a very low base of knowledge. I actually, if you saw the post where if you saw the post where we were talking about this, Jacinta mentioned that she had a client going into residential aged care, and a retirement village, and then Michael was saying, well, that's actually totally different to residential aged care, and I didn't even realize that was something that was different. So I've got a lot to learn. Hi Liz, thanks for joining. We're just waiting for Michael. We've had a few tech issues at the beginning. Also got a text from Jared wanting a shout out. I can't even see that Jared is on, but Jared, if you're on, you've got a shout out. Well done. Yeah, I know we were talking about this. I sat through a whole conference at last year's Tax Institute Death and Taxes. Okay, Michael, let's see if I can add you. Michael, I'm just trying to bring you on camera. Let's see if that works. Hi, Liz. Thanks for joining. Michael, hello.
Hello. Has that fixed the echoing?
No. I'm going to try headphones at my end. Do you have headphones at your end?
I don't have any here, no.
Okay. I've never had this issue before. Let's see if that does anything.
Coordinated seamless technology experience here.
Is that still giving you some echo?
Yeah. Look. Let's persevere. Michael, you're doing all the talking anyway. So I'll just hand over to you and keep it quiet. Attendees, if you are getting an echo from Michael, then let me know.
So thanks for sort of having me. I think one of the things we sort of spoke about in the prep is it's probably useful just to have a very sort of basic overview of how that residential aged care system works and in particular the sort of funding side of it and then sort of how that sort of feeds into the estate planning and decisions made there. So I think as some of my sort of fellow financial planners have already alluded to in the comments there, is they haven't made the system all that simple to understand. But there's largely 4 different fees that can apply when somebody goes into aged care, and two of them really just aren't affected in any way by sort of what a person has in terms of their assets and their income. The first of that is what's called the basic daily standard care fee. That's actually set at 85% of the age pension. So at the moment, these figures index every 6 months, but it's $51.21 a day. So in theory, if somebody goes into care, they have no sort of assets or other income to their name, they'll pay that 85% of their age pension to the care provider and nothing more. So that doesn't change for anybody. The other one is what's called an extra services fee. Now, sometimes a facility, it's really sort of the add-ons that are somewhat outside of the regulated system. So they might say, look, you can have Foxtel in your room and a glass of wine with dinner, and that costs $12 a day. That's just sort of set by the facility, and once again, it's not at all impacted by what the person has in terms of their income and assets. The 2 big ones where a lot of the variability exists is there's what's called a means tested care fee, and this is actually a fee that can vary quite significantly, and it's based on what are the assets and the income that the person has. So that's where, in particular, where it relates to estate planning is if assets are being left to somebody who is in care or is likely to enter care in the near future, that can actually alter how much they have to pay for that means tested care fee. And that, to give you an example, there are actually some annual and lifetime caps, and because of the indexation every 6 months, they end up funny numbers, so I'm going to round them a little bit, but you can't be asked to pay more than, it's about $27,500 a year in that means tested care fee right now, and then there's actually a lifetime cap that applies to that as well. which that one is sitting at, I've got my little sheet here in front of me, about $66,000 at the moment. So somebody who sort of hits that $27,500 maximum within the year, after about 2.5 years, they're actually going to hit that lifetime cap and they don't have to pay that ever again. And then the final part, and this is where people are sort of most familiar or sort of heard a lot more things about this, is there's what's called the accommodation payment. And that's commonly spoken about in the form of the refundable accommodation deposit. So that might be sort of $400,000 or $500,000 that the aged care facility asks you to pay to them. It is, as the name suggests, it is actually refundable when the person sort of leaves or passes away. And there's also an option to, if you don't have that money or you can't sort of get access to it as a lump sum, you can pay it at a daily rate, which works out to about 5.7%. And there's a bit of a balance there. Somebody who has the means will be required to pay that. Somebody who doesn't have the means may not actually have to pay that, or they may only have to pay part of that amount. So that's the sort of the 4 different fees. So the basic daily care fee, the extra services fee, the means tested care fee, and then also the accommodation payment.
Okay, thank you so much for stepping us through that. So as lawyers or people assisting with structuring the estate plan, how do those payments factor into what we should be doing when we're helping people craft their estate plan?
Yeah, so I think one of the main considerations is if particularly you're working with somebody and they're talking about leaving money to somebody, and typically where we might see this is where it might be, say, an older client, so somebody who's starting to get into their sort of 70s and above, and they might be thinking of beneficiaries such as brothers or sisters or long-term family friends who are sort of in the same age bracket. Is just being aware that leaving those assets are going to increase those care costs that they have to pay, the ones that are dependent on what means they have, and that can also have a related effect of affecting age pension payments that they might be receiving as well. So obviously it's tough for the estate planning solicitors because they're not there to be sort of social security and aged care experts, but it's, I guess, asking that question of, are you aware of the financial circumstances of the person that you're thinking of leaving the money to, and whether this might have an impact, and whether there might be an alternative. If they're thinking of leaving it to a brother and sister or sister, that they may prefer, if they knew that this is actually going to just sort of be eaten up by costs for that person. Maybe the brother or sister has children that they might actually prefer to leave the money directly to, or a balance of the two. It's that sort of asking the question of, okay, the people you're nominating as beneficiaries, what are their circumstances and what's the impact that inheriting this money might actually have for them?
Yeah, good point. You may not actually be doing them a favour by leaving them an inheritance. And so I got a question come through from Jay about I guess estate planning for people who are entering aged care themselves. I don't know if you can see that there, Michael. But he's saying, what happens if someone sells their home and then uses that money for the deposit for aged care. What's the impact on the estate plan then?
Yeah, so one of the key things is that there are around the home a number of different concessions that can apply. If somebody sells the home, then it immediately becomes a financial asset, and it goes into those assessments for what's their cost of care, and then also what's the impact on their other social security entitlements like the age pension. Now, there are some situations where the home can actually not be included in that assessment. The most basic is where what's called a protected person remains in the home, and the most common protected person is a spouse. So if you've got a couple and one person needs to enter care and the other person stays in the home, then in that case the spouse is a protected person. The value of that property is not going to be assessed in working out what the person entering care has to pay. Whereas obviously if you have actually sort of sold it and it's sitting there in the bank, then that very much does form part of the assessment. There are also situations where carers and the like can be protected persons. There's a few sort of extra tests there, but it's one of those things that it is quite relevant to sort of get that advice and get those numbers on what happens under these different scenarios, because even if somebody does actually keep the house, it can be assessed at a lower amount for a period of time. That can sort of impact things too. It also starts to become, I guess, a little bit relevant to what but by this stage there's often sort of a power of attorney sort of managing affairs. Working out, is there actually any sort of desire to keep the house sort of as an asset, or is nobody actually sort of connected to it or expecting to receive that? A lot of the sort of the technical papers and things like that we as financial planners sort of read about this, talks a lot about these rules around the exemptions for houses and the like there. I would actually say that in my experience, a lot of the sort of the family members actually don't necessarily have any desire to see the house sort of passed down the way, because typically if mum or dad are sort of going into aged care in their 80s, the kids are probably in their sort of 60s or something like that, and quite possibly have their own sort of family home and multiple children. Can't sort of split the home effectively, without selling it anyway.
And we've got a question come through from Christiana. In terms of establishing that there is a protected person in the home, do you know what evidence is needed? Do they have to be on the title, or is it enough that they just occupy the home?
They don't have to be on the title. It's a fairly simple test for a spouse. Where you're starting to talk about carers and the like there, it then actually sort of, a lot of the aged care rules are very, very closely tied to the social security rules. So for carers, for example, it looks at was that person providing a level of care that would have made them eligible for a carer's allowance or a carer's payment, which is a separate social security benefit. So it just sort of follows that.
And with the deposit, so say they sell the house, put the proceeds into the deposit. Do they get that full amount back after they pass away, passing into the estate, or are there other rules adjusting that?
So yes, and this is probably one of the common misconceptions, and this is only to do with prior to 2014, there was a whole different set of aged care funding rules, and you used to actually have a large sort of deposit or bond that could be paid, but then the facility, depending on how long the person was in there, would retain a certain amount. But what happens under the new rules is it is a fully refundable deposit. So if the person has sort of paid over $500,000 and they pass away, that $500,000 is paid back. There's two sort of, I guess, caveats to that is the person can actually choose to have their other fees that might be payable taken out of that. So they do actually have an option where they might say, look, I've got to pay a $10,000 a year, let's say the means tested care fee. I've given you $500,000 as the deposit. I actually want you to take the $10,000 out of that rather than me paying it to you directly. But that's very much that person, they have to elect to do that. There's no sort of automatic deduction. And one of the other sort of key things is the Aged Care Act rules require that refundable accommodation deposit is repaid to, if the departure is as a result of somebody passing, it's paid to the estate. And where that's particularly relevant is sometimes you see situations where children may actually be considering lending money to their parents to actually pay that deposit. So if you imagine a situation where there's, say, 3 children and all are equal beneficiaries of the estate, but one child has said, look, actually, we want you to sort of be able to secure this place, not have to worry about it. We're going to lend you the money. So they've lent them $500,000. Let's imagine there's no other assets. That $500,000 gets paid back, but it gets paid back to the estate. So if the will says, well, the estate goes equally amongst my 3 children, that's actually going to take that $500,000 from one child and divide that up amongst their other siblings, which is obviously there are pretty few scenarios where you think anybody would be happy with things turning out that way.
Yeah, that becomes quite problematic, especially if that's all happening at the time when the parent has lost capacity,
yes.
and we're navigating powers of attorney issues, and they can't remake their will.
That's the biggest issue that we see. Is often the time that this is being sort of done and arranged is you might be able to say, well, it's okay, we'll sort of put the money in and that mum, dad, whoever it is will put in their will that I get that money back. But yes, more often than not, the reason that they're entering care is they've lost capacity to look after themselves, and I understand it's a slightly different test, but that there's a good chance that means they've lost legal capacity to make a will to reflect that.
I think you could get around it by documenting the payment as a loan from that adult child to the parent. But that would have to happen under a power of attorney. And it would be a conflict of interest transaction. Which I think you could probably do it, but there would be a few hoops to jump through, and depending on who the attorneys are and how amicable everybody is, it could be problematic.
Yeah, the other trick too as well is in that scenario, so let's say it's $500,000 that's actually lent to the parent. That $500,000 then becomes an assessable asset of the parent in determining their care costs. And keep in mind that typically the situation where the children might be looking at lending that money to the parents, it's because the parents don't have significant accessible assets of their own. And what that actually means is that means they are more likely to be in the sort of scenario there where lumping an extra $500,000 onto their accessible assets actually has a really dramatic impact on what they're paying for the care. If the parents had sort of $5 million or income sort of equivalents, one, they're probably not going to need to borrow the money from the children, but the children are actually they're probably already at all the sort of maximum payments anyway that it wouldn't impact things, but they're not the people who need to borrow the money off the kids.
So you're saying it's almost like it's double counted if we document it as a loan.
In a way, yes, yeah. There was actually a case that somebody went through the Administrative Appeals Tribunal, and what they argued was, well, basically we've lent the $500,000. It's secured by that bond, and therefore that bond shouldn't be assessed under the Social Security, which sort of follows the aged care rules, or it should be assessed less the loan. They actually won that case, and then the government changed the law to reflect what they intended it to be. So it's actually quite clearly written in now that will be counted every time.
I mean, I think this just demonstrated the importance of the different professions coming together to work on a fully informed solution, because just looking at it through the legal estate planning mindset obviously trigger problems from the financial side.
Yeah, that's right. It's quite easy to sort of come up with something that is very neat on the estate planning side and actually meets everybody's needs there, that then in turn increases the cost because it is also heavily means tested. There's not that much of the fees that are sort of fixed and that people pay regardless. A very large part of it is a balancing act between what they actually have. So if you start making that person appear to have more, then they will end up having to pay more.
Now I think Jake has asked, does the deposit get paid back with interest?
No, it doesn't. So if it's $500,000 in, it's $500,000 out. The one thing that sort of runs alongside that is a lot of the changes that occurred in 2014 was to what they used to have was you'd have an aged care facility and you would have high care sort of within that facility or on that campus, which is the sort of the hospital level type care, and you would have low care for people who didn't actually have as high a need. What they found was two things: is actually not a lot of people wanted to go into an aged care facility when they didn't have high care needs. It just wasn't attractive to them, but also that it effectively cost the government less to provide that lower level support to people in their own home rather than sort of in these specialised facilities. So the system is now very much the high level care is in the residential aged care, and then there's a whole bunch of support that's delivered into the home to sort of help people stay in their homes for longer. The flip side of that, and this sort of comes to Jake's question about whether there's interest paid on the deposit, is people under the new system actually enter care. They're entering much later than they used to because they've had that support to stay in their home. But it does mean that when they get there, they are older and they are sort of sicker or have higher needs than they used to. And you can actually pull it out from, it's either one of the aged care authorities or it might be the Institute of Health and Welfare, but you can get the stats on actually how long people stay in aged care, and it is actually quite short. I think the average might be under 2 years, so there's not a huge, on the finance side you might say, well, okay, I give somebody $500,000 today and I get $500,000 back in sort of 10 or 15 years time. It's really lost a lot of its value. The average stays are short, so you don't lose so much of that value over time. That's a tricky conversation to sort of work in with clients at the time because it's a little bit morbid, but yes, it does exist.
Now you mentioned this in the comments in response to Jacinta saying she had a matter where someone was going into a retirement village. So the rules relating to retirement villages are totally different to aged care.
Yes, yeah, entirely different. So all the retirement villages are actually under state and territory legislation. So whereas the residential aged care is all Commonwealth legislation, the retirement village side, the costs they're not means tested like the aged care. So the retirement village provider just sort of says, look, this is our facility, this is what the costs are. That is very much governed by that state and territory legislation, but it doesn't have that, there's nobody there sort of saying, well, you've got $2 million more than the person next door, so you pay a higher maintenance fee. It's just what the budgets are set at. The confusing part about that is more and more what you're finding is the providers are actually building both on the same sort of campus in a way. So what you'll actually have is a bunch of retirement village units, and then somewhere on that sort of same block, they actually have a residential aged care facility, and as much as possible they try to allow people to move between the two. Because a lot of people, particularly those looking at buying into retirement villages, like that idea of the term they use is ageing in place. There's a little bit of a trick there in that I don't know every state and territory sort of legislation, but certainly ACT, I think in New South Wales, and I do think it probably is common across each state and territory, is a retirement village provider isn't normally able to guarantee to somebody, well, if you buy into our retirement village, then you will be guaranteed entry into the residential aged care. Because they just may not actually have the beds available there when somebody needs to make that change. Having said that, I understand from hearing from some facilities that on the residential aged care side, there's nothing there that says how they have to manage a waiting list. So a lot of them may, if they have a vacancy in the residential aged care, the first people that get the call may well be the people who are in that sort of related retirement village. So that's the way that they do sort of, as much as possible, try and make that happen for people, but they can't actually sort of guarantee it for them.
And the rules on getting your back are different in a retirement village, as I understand it. And if you we weren't meant to talk about this today, so if you don't want to, don't worry.
That's right. Yeah, no, there's two things. Yes, they are different, and particularly different in the way they structure them. It's much more common to have. They call them all sorts of different things, deferred management fees, but it's effectively an exit fee. So it might be, for example, you buy this retirement village for $600,000, but there's a deferred management or exit fee of, let's say, 2% of the value for that for each year that you stay, and there'll often be a cap. So it might say, well, it's 2% a year for up to 5 years, so 10%. So in that scenario, if you moved in 2019, paid $600,000, and then moved out 5 years later in 2024, you've reached that maximum sort of 10%, so you might only get $540,000 back. Just to become even more confusing, they might then take that same unit and say, well, that's one offer. It's $600,000 on the way in, and you pay 2% a year for 5 years. They might say, well, you can actually have the very same unit, and you only have to give us, say, $300,000 on the way in, but those exit fees will be much more aggressive, that say after 5 years, you may get none of the $300,000 back, or only $100,000. So it'll actually be the same sort of unit or property, and they'll have different structures on how you can choose to pay for that, and then that will also reflect the state and territory legislation. So, for example, I think you're practicing on the Gold Coast. You've probably got you're not far from the Queensland-New South Wales border there. You could see quite substantially different offers sort of either side of the border just because of what that state legislation allows them to sort of do or offer to people.
It's really interesting. I had this with my family recently and my nan. And she was in a retirement village for about 10 years. And then exited and went to aged care for about another 2 years. And they couldn't sell the retirement village, so we didn't get the exit payment until they ultimately sold her original retirement village unit. So it was all very impractical in the circumstances, moving between the two.
Yes, and that's where I think that there has been, I think New South Wales, for example, might have updated their legislation quite recently, and that's a very common problem. I think they're trying to sort of work out, what do you do in terms of, does the provider have an obligation to buy that back or similar? So, I think at the moment that can vary quite a lot based on who the provider is, obviously to what the actual village is, because some might have a waiting list of people who want to buy in there. Others might just not be as popular, because you can see that too. People can be in retirement villages for a much longer period of time. So somebody might have bought something 15 years ago that, just looking at it on a features basis, is not nearly as sort of comparable as the things that people are building now. So they may actually have trouble sort of selling that older style unit there, because it might just not be what people are attracted to anymore.
Yeah, I think you're right. And actually, I still don't think they've sold it, but she has since passed away, and they bought it back, I believe, or the payment has come through now. Well, so enough about my dear old nan. You mentioned when we were speaking the other day, this all becomes really relevant when quantifying family provision application claims as well.
Yes, and I think a lot of this stems from, in particular, that accommodation payment and that refundable accommodation deposit, because that's people are very conscious of the sort of the lump sum cost. That's the way a lot of the sort of facilities really talk about it, even though they sort of the options are available under the legislation for people to pay it as a daily payment. So you may be sort of providing advice to an executor where there's been a family provision claim, and that person obviously has to sort of establish what their needs are. And what you sometimes see is, and whether this is just deliberate or the fact that it's a really complicated system and hard to understand, that person might be sitting there saying, well, I want to go into this aged care facility that's down the road. I need to do that because of my health and my needs. Their refundable accommodation deposit is $700,000. So they're sort of sitting there saying to the executor and the person who's getting advice about this claim is like, well, gee, at a minimum, I actually need $700,000. Whereas the reality is that person has a lot more options. Giving them that $700,000 out of the estate might actually drive up some of those means-tested fees. So arguably, the need. So somebody who, if there's a $700,000 deposit, that would equate to, if they didn't actually provide that deposit and just paid the daily fee, now that'll be about $42,000 a year. Now, typically that person needing the care might actually have quite a short life expectancy. That even at that sort of most basic level, you might be able to say, well, hold on, actually, if you're likely to be in there for say 7 years, and it's $42,000 a year, well, that's I'm testing my mental maths now. Somewhere around $290,000 $6,000, give or take a few. So you can sort of see there in terms of that person's need, from $700,000 down to about $300,000 is quite substantial. So that's what part of that family provision process is, that person saying, well, these are my needs that have to be met. The information that the sort of the executor or the solicitor providing advice on that claim might be getting, might not really be the full picture. And as I said, that could be because the person is not presenting the full picture, because of course they would like the claim to be higher, but it's also actually just as likely that they don't even understand, and obviously the sort of executor has the duties there to sort of consider and I guess understand what the duty may be. So that's something that we've done a bit of work in, is actually providing effectively sort of expert reports saying, well, actually in these circumstances, this is what the care fees would be, and if it's done, if this much is provided, the person would have this impact on their age pension as well, so that you can really start to sort of understand, well, what are the actual dollars rather than what's just being sort of given to me.
That makes a lot of sense. And again, just another reason why we should be collaborating between the professions. Now, I have only got one more question for you. Have you got any war stories about where failure to plan properly has made this go really pear-shaped?
Look, I think that the biggest part is that there's not a tendency to address this ahead of time. So the majority of the referrals that I get for this are when it's mum or dad has had the proverbial fall, they've gone to the emergency room, and the immediate problem has been fixed up, but the doctor is sort of telling the family, mum or dad can't go home. It's not suitable, it's not safe for them, and now you need to find somewhere for them to go, and at the same time, you've typically got a sort of a very nice but very firm sort of nursing unit manager saying, mum or dad is in an acute care bed, doesn't need acute care anymore. What are you doing? So you end up with these really sort of time compressed decisions. And I think, as we sort of touched on, it's complicated. So it can be difficult to make those decisions under that sort of pressure. It also requires a detailed understanding of what the person's sort of income and assets are, because you have to actually declare all of this to the Department of Human Services to work out what's going to be paid. Often it is the first time that the person may have the power of attorney, but they may not have actually been involved in the management of any of those finances, so they may not even know where to start. And the big thing for us is often a lot of those decisions are, right, well, we can work out what the fees are that have to be paid. Then the decisions become about, well, where do we actually pay that from? And then, one of the things that we find is a person might have, for example, a share portfolio, and the attorneys may actually be able to sort of put their hands on, the statements that show what they have. But if they're going to consider the sale of those to pay that deposit or paying the ongoing care fees, that's going to have capital gains tax implications. And until you can show what was paid for those shares, nobody's going to actually be able to reliably estimate for you what that tax is. So you end up in this situation where all the sort of the care side of things is saying, make a decision, make it quickly, get mum and dad into care, and you're trying to work out, well, actually, how much can we afford to fund? If we've worked out that we can actually afford it, or how are we practically going to do that? Where is the money going to come from? And they don't actually have all the information to make that decision. So my encouragement is certainly that for people to, and this is probably where the estate planning solicitors have a role, because as I said, my referrals typically come when the event happens. I don't always get the opportunity. I may not be sort of dealing with these people as clients before then. It's when they're sort of making wills and things like that it's actually sort of really useful to say, hey, have you actually thought about what this process is going to look like? Do people actually know what the numbers look like? But also too, have you actually thought about what you would like to happen? Because it's far better to have had some input into that than everybody else making the decisions on your behalf, when you're sort of in hospital or anything like that.
Yeah, I think that's a really valuable point, Michael. It's so sensitive. I know in my family, we tried to raise it with both my grandmothers, and they just wouldn't talk about it. And it was that exact situation. They'd had a fall, and then my mum was running around like a headless chook, trying to sort everything out at the last minute.
Yeah, I actually think there will be a bit of a shift. There's a generation going into care sort of right now where probably more likely that their parents probably sort of died in the home or similar. They didn't have that longer period of frailty, so they haven't had any exposure to this whole system and process in the past, and so they can quite naturally be quite reluctant about it. I do think, as you sort of spoke about there, the experience of your mum, that sort of generation that has seen, how difficult it was for their parents when they didn't acknowledge the sort of the requirement to do so, and the impact that has on the people who actually love and care for them and are trying to help them. I suspect / hope that might actually drive them to be a bit more aware and proactive and sort of saying, actually, I love you, but I don't want you picking, where I go. I want to sort of pick it in advance as much as I can and tell you, when I can't make the decisions, this is where you should be looking at and things like that.
Well, Michael, I think we've had enough of your time. That was so insightful. You've definitely got things working for me in terms of identifying how to raise this conversation and when to bring in specialists. So thank you so much for being so generous and giving us so many insights. And thanks to everybody watching and putting up with their tech echo.
I will certainly have headphones ready next time.
I don't know if it was you, actually. I'll work this out for next time. Thank you so much, Michael, and thanks to everyone who asked their questions.